Lesson: Risks in Contract Formation. Contract formation is a fundamental aspect of business transactions, legal agreements, and partnerships across various industries. However, the process of forming a contract is fraught with potential risks that can lead to significant legal and financial repercussions if not managed properly. Understanding these risks and implementing strategies to mitigate them is crucial for professionals involved in contract management, negotiation, and compliance. One of the most prevalent risks in contract formation is the ambiguity in contract terms and conditions. Ambiguities can arise from vague language, undefined terms, or inconsistencies within the contract. These ambiguities may lead to disputes between the parties involved, as each party might interpret the terms differently. To mitigate this risk, professionals should employ a clear and precise drafting strategy. The use of plain language and the inclusion of definitions for key terms can help ensure that all parties have a mutual understanding of the contract's provisions. Additionally, tools such as the Contract Clarity Checklist can be utilized to review contracts for ambiguous language before finalization. Another significant risk in contract formation is the failure to adequately address contingencies. Contracts often lack provisions for unforeseen events, which can lead to disputes or contract breaches. The inclusion of force majeure clauses, termination clauses, and dispute resolution mechanisms are practical tools to address this risk. A force majeure clause should clearly outline what constitutes a force majeure event and the obligations of the parties in such circumstances. Termination clauses should specify the conditions under which the contract can be terminated and the consequences of termination. Dispute resolution mechanisms, such as arbitration or mediation, provide a structured process for resolving conflicts, thus minimizing the risk of litigation. The risk of non-compliance with legal and regulatory requirements is another critical factor to consider during contract formation. Contracts must comply with applicable laws and regulations to be enforceable. Failure to do so can result in the contract being declared void or unenforceable, leading to financial losses and reputational damage. Professionals should conduct thorough due diligence and legal reviews to ensure compliance with relevant laws. Utilizing compliance management frameworks, such as the Regulatory Compliance Checklist, can aid in identifying applicable regulations and ensuring that the contract adheres to them. This checklist should include a review of industry-specific regulations, local laws, and international standards that may impact the contract. Additionally, the risk of entering into contracts with financially unstable or unreliable counterparties poses a significant threat. Conducting a thorough assessment of the counterparty's financial stability and reputation is essential to mitigate this risk. Tools such as financial due diligence checklists and creditworthiness assessments can be employed to evaluate the financial health of a potential counterparty. This assessment should include an analysis of financial statements, credit ratings, and any history of litigation or contract breaches. By understanding the financial stability of the counterparty, professionals can decide whether to proceed with the contract or implement additional safeguards, such as performance bonds or guarantees. The risk of misrepresentation or fraudulent inducement is another concern in contract formation. Misrepresentation occurs when one party provides false information or omits crucial facts, leading the other party to enter into the contract under false pretenses. To address this risk, professionals should include warranties and representations in the contract. These clauses require each party to affirm the truthfulness of their statements and disclosures. Furthermore, conducting background checks and verifying the information provided by the counterparty can help identify potential misrepresentations or fraudulent actions before the contract is finalized. Another aspect of contract formation that carries risk is the negotiation process itself. Poor negotiation strategies can lead to unfavorable contract terms, resulting in financial losses or legal liabilities. To enhance negotiation outcomes, professionals should adopt structured negotiation frameworks, such as the principled negotiation approach, developed by Fisher and Urey. This approach emphasizes separating the people from the problem, focusing on interests rather than positions, generating options for mutual gain, and using objective criteria to evaluate options. By employing this framework, negotiators can achieve more favorable contract terms while maintaining positive relationships with counterparties. The risk of inadequate documentation and record keeping during contract formation cannot be overlooked. Proper documentation is crucial for maintaining a clear record of the contract terms, negotiations, and any amendments made over time. Inadequate documentation can lead to misunderstandings, disputes, and challenges in enforcing the contract. To mitigate this risk, professionals should implement robust document management systems that ensure all contract-related documents are accurately recorded, stored, and accessible. This includes maintaining a comprehensive contract file that contains drafts, finalized contracts, correspondence, and any related documents. In addition to these risks, the lack of a standardized contract review process can also pose challenges during contract formation. A standardized review process ensures that all contracts undergo a thorough evaluation before execution, reducing the likelihood of errors or omissions. Implementing a contract review framework, such as the 4 Eyes principle, can enhance the review process. This principle involves having at least 2 individuals independently review the contract to identify potential issues or overlooked provisions. By incorporating multiple perspectives, the likelihood of identifying and addressing risks increases. Case studies further illustrate the importance of addressing these risks in contract formation. For example, the case of Transatlantic Financing Corp. v. United States highlights the significance of addressing contingencies in contracts. In this case, the absence of a clear force majeure clause resulted in a dispute over unforeseen events that impacted contract performance. The court's decision underscored the need for explicit contract terms to manage such risks effectively. Statistics also emphasize the potential impact of contract formation risks. According to a survey conducted by the International Association for Contract and Commercial Management, over 70% of contract disputes arise from unclear or ambiguous contract terms. This statistic underscores the importance of clear drafting and thorough review processes to mitigate risks associated with ambiguities. In conclusion, the risks associated with contract formation are diverse and can have significant implications for businesses and professionals. By understanding these risks and implementing practical tools and frameworks, professionals can enhance their contract formation processes and mitigate potential challenges. Clear drafting, contingency planning, compliance management, counterparty assessment, negotiation strategies, documentation practices, and standardized review processes are all essential components of effective contract risk mitigation. Through continuous learning and application of these strategies, professionals can navigate the complexities of contract formation with confidence and competence.